Greetings. My name is Z. Felicia Jordan, and I'm an attorney, but I'm also the director of the Social Security Representative Payee Program at Disability Rights Florida. I'd like to present to you how to be a grown-up, transition, and finances for students with disabilities. This is for your information. Any content, whether provided by Disability Rights Florida or its presenters, is presented for educational, general reference, and informational purposes only. It is not intended to serve as legal or other advice, and it is not intended to be a full and exhaustive explanation of the law in any area, and should not be used to replace legal advice of your own legal counsel. And Disability Rights Florida will make no representation or warranty that the content is accurate, complete, or current for any specific or particular purpose or application. The participants of this presentation should contact their attorney to obtain advice with respect to any particular legal matter. No reader, user, or browser of this presentation should act or refrain from acts based on this information on this site without first seeking legal advice from counsel in the relevant jurisdiction. Only your attorney can provide assurances that the information contained herein and your interpretation of it is applicable and appropriate to your particular situation. The use of and access to this presentation or any of the links or resources contained within this presentation does not create an attorney-client relationship between the user, reader, or browser and website authors, contributors, contributing law firms, or committee members and their respective employers. The learning objectives of this presentation. After this workshop, you'll be able to list what transition services are, who is required to provide them, and what they should help the student accomplish. To identify priority issues to look for during a school-to-work transition for SSI and Ssdi beneficiaries. Locate organization and resources to help manage potentially complicated transition issues for students. 18th birthday, balloons and party hats, cake, adulthood. What? She is all grown up. Not really. A person is considered an adult upon reaching the age of majority of 18, regardless of disability, and that includes cognitive impairments. Legally, that individual is entitled to make all of their own decisions. So what can we do? So we can prepare a child for adulthood, and this is also known as transition to adulthood. And we can do this with education and training, employment, and community experiences. Transition from school to work. By age 16, students covered by IDEA are required to have a further plan as they grow into their late teens. In Florida, we start the process at age 14 and develop what is called a Transitional Individualized Education Plan, otherwise known as a TIEP. The TIEP is designed to be a result-oriented process that focuses on improving the academic and functional achievement to facilitate a student's movement from the school to post-school activities, including post-secondary education, vocational education, integrated employment, including supported employment, continuing and adult education, adult services, independent living, and community participation. So what does this transition process accomplish? It takes our young people with disabilities from childhood to adulthood. It helps them move from being dependent to being independent both socially and financially. It includes the movement from the IDEA services or Section 504 plans in an education setting to a vocational rehabilitation services, and it may implicate Social Security benefits and healthcare benefits. So what should each transition plan cover? Each transition plan, or TIEP, should cover the youth's goals and support all the supports and services that young person with a disability would need to prepare to be have the fullest life possible as an adult. The transition plan looks to the needs, changes, and possibilities of adulthood. The IEP, or education plan, focuses on preparing for work as an adult. If the education system Vocational rehabilitation agencies and private and governmental services, social services, can provide a service or support, and that person covered by the plan needs it, then that plan would show the way how to get it. So who provides transition services? Well, first of all, schools and vocational rehabilitation programs are both required to provide transition services to youth between the ages of 16 and age 22. There's law cited here, but I will not cite it individually, but it is visual on the screen, so you could be able to use it as at your leisure. So the services provided by the United States Code basically is pursuant to two documents, the IEP and the IPE. And I know that's confusing, but those both cover the transition services. The individual educational plan, or the IEP, is developed at school, and the individual plan for employment, otherwise known as the IPE, is developed with the vocational rehabilitation agency. So how does the law define the transition services? Well, the law defines it as meaning a coordinated set of activities for a student, designed within an outcome-oriented process that promotes movement from school to post-school activities. And this includes post-secondary education, vocational training, integrated employment, including supported employment, continuing and adult education, adult services, independent living, and community participation. So these coordinated set of activities shall be based upon the individual student's needs, and that's important, the individual student needs, taking into account the student's preferences and interests, and shall include instruction, community experiences, and the development of employment and other post-school adult living objectives, and when appropriate, the acquisition of daily living skills and functional vocation evaluation. And again, that is 29 U.S.C. section 705, subsection 37. So what are transition services? Well, these may include guidance and counseling, on-the-job training experiences, vocational training programs, and this includes college, assistive technology devices, and many other services. So we have some case law in transition here that basically I will not read, but it is there available to you at your leisure to review and look up. And we have shepherdized these, and these were current as of the date of this recording, which is May 31st, 2021. So let's talk about Florida's vocational rehabilitation agencies. Florida Vocational Rehabilitation Agencies, or the Division of Vocational Rehabilitation, basically means that a person is eligible for vocational rehabilitation services if that person has a disability and requires vocational rehabilitation services to prepare for, enter, engage in, or retain gainful employment. And please see the Florida statute listed below. The Division of Blind Services, or also known as DBS, provides services to individuals who are blind, meaning that an individual is having a central visual acuity of 20/200 less in a better eye, with correcting glasses, or a disqualifying field defect in which the peripheral field of vision has contracted to such an extent that the widest diameter or visual field subtends to an angular distance no greater than 20 degrees. How to obtain Florida's vocational rehabilitation services. The application of services must be signed by the applicant, and we have two links below that provides one for the Division of Vocational Rehabilitation Services and the other to the Division of Blind Services. There is no requirement to submit the application prior to the initial meeting, and if you click on one of those links that are listed below, they will give you the access to those applications for those Florida Vocational Rehabilitation Agencies. An individual may select or have appointed by a court a personal representative. This application must be designated to a counselor. Disability Rights Florida can help with supervised referrals to ensure the assignment of a counselor and the initial meeting if needed. Please call our 800 number as listed at the end of the presentation, and we'll be able to assist you in that manner. Eligibility determinations. A determination for eligibility for the Florida Vocational Rehabilitation Services must be made within 60 days regardless of eligibility. An extension may be sought if there are exceptional and unforeseen circumstances, and this must be agreed to by the client, which is you, and includes a time frame for eligibility. Individuals must have legal status and authorization to work in the United States. They also must be present in the state, if not a resident of the state, meaning, i.e., college students from other states. They also have a presumption of eligibility for Social Security beneficiaries. So let's look at the eligible disabilities. A mental health disorder, chemical dependency, adjustment disorders, short-term mental health disorders, intellectual disabilities, specific learning disabilities, hearing, speech, or vision impairments. And specific documentation requirements for each disability type is outlined in the Florida Administrative Code Rules 6A-25.005. There is an order of selection when basically the cases are very busy for vocational rehabilitation and the Division of Blind Services, and they have an order of selection. They were being instituted by Florida Administrative Code 65A-25.006. The three categories are most significant disability. Most significant disability is Category 1. Significant disability is Category 2. And individual with a disability, which is Category 3. The exception to this is individuals with IPEs signed prior to February 19, 2014. Continued services will be uninterrupted. The order of selection with the disability status. Disability status shall be determined by the individual's limitations and functional capabilities or capacities, and the individual number of needed primary services and the time those services need to be provided, i.e. more or less than 6 or 12 months. And if waitlisted while in school, contact the student's DVR counselor prior to exiting school to determine if your category should change when your young adult exits school. Under WIOA, the student may qualify for some services while being in the order of selection and still being waitlisted in school. So they look at the functional capabilities or capacities, and we're looking at mobility, communication, self-care, self-direction, interpersonal skills, work tolerance, and work skills. Primary services that we're looking at in the order selection is counseling and guidance, training programs, physical restoration, mental restoration, supported employment or extended services, employment services, occupational licenses, tools, equipment, or initial supplies, prosthetics or orthotics, rehabilitation technology, interpreter services, self-employment services, and community-based work experiences. An individualized plan for employment, otherwise known as the IPE, is a written document capturing the individual's specific employment outcome. This is very important because we're always looking at that on that IPE, that job title. They're looking at the services and the service providers needed in order to reach that employment outcome. The time frames for service initiation and provision, responsibilities of the division and the individuals, as well as any third parties who will provide comparable services. And this will be all outlined or should be outlined on this individual plan for employment. So before you have any of these services, you want to make sure that any of them that will be contained in this document. Required coordination. The IEP for a student with a disability who is receiving special education services must be coordinated with the IEP for that individual in terms of goals, objectives, and services as identified in the IEP. So basically, both documents are written on behalf of the transitional student, but we have to make sure that they mirror one another in regards to goals, objectives, and services, so that way we can make sure that the student's outcome for both the employment as well as the exiting school basically are on the same page on what the services and goals and objectives that student needs. Time frames. DBS, or the Division of Blind Services, has a 60-day clock for IPE development. So that means that after eligibility, DBS only has 60 days in order to have a written document in regards to that individualized plan for employment. Vocational Rehabilitation has a little longer time frame. The Division of Vocational Rehabilitation Services has a 90-day clock upon eligibility for IPE development. Ticket to Work program. So what is the Ticket to Work program? Well, Social Security beneficiaries between the ages of 18 and 64 who receive employment-related services and supports under the Ticket to Work program and Work Incentive Improvement Act of 1999. These include individuals who are recipients of the Social Security Disability Insurance, was known as Ssdi or Disability or DIB, or the Supplemental Security Income, which is SSI. The ticket is not a physical document, but it's a voucher for services that helps the eligible beneficiaries transition to work through employment networks, otherwise known as ENs, which include both Florida vocational rehabilitation agencies as well as some private organizations and providers. Social Security Administration will reimburse the ENs participating in the Ticket to Work program when a client works at a sustained level. The Ticket program may provide protection from continuing disability reviews while working or going to school. Work incentive programs. Work incentive programs are otherwise known as WIPA, or WIPA programs. Work incentives that enable Social Security beneficiaries to transition from benefits to sustained earning through employment and to continue to receive medical benefits while working. Programs that use community work incentive coordinators who counsel Social Security beneficiaries on their benefits and possible impacts when working. There are 4 WIPA programs in the state of Florida. There's the Service Source Abilities in Clearwater. There's the Brevard Achievement Center in Rockledge outside of Cocoa. There is a Center for Independent Living in the Central Florida in Orlando. And there's Independent Living Resources for Northeast Florida / Opportunity Development in Jacksonville. These will cover all 67 counties in Florida, and please contact us for further information if you would like to know whether or not or which WIPA would cover your local area. So SSDI work incentives, trial work period. This is a period at Social Security defines as allowing the beneficiaries to try working without losing benefits. The period lasts for 9 months, which can be non-consecutive, and a rolling 60-month period, otherwise known as 5 years. And again, does not have to be consecutive. A month counts during the period when a beneficiary earns more than the monthly threshold for that year. In the year of 2021, the monthly threshold is $940. SSDI Work Incentive Extended Period of Eligibility. After the trial work period is exhausted, meaning that you reached that 9 month, there is a 36-month period where the beneficiaries may still obtain benefits if they do not earn more than substantial gainful activity, otherwise known as SGA. I know this is a lot of initials and acronyms, but it'll be very useful to you later on if you ever need them. For the year 2021, substantial work activities is listed as $1,310 for those individuals who are working while disabled, and $2,190 for individuals who are blind or have visual impairments. A reapplication for benefits are not required if it's done within the extended period of eligibility. Ssdi work incentive, impairment work-related expenses. Expenses paid for by the beneficiary for their work, but are deducted from earned income. So, impairment-related work expenses would include service animals, medicine, medical supplies, devices, personal care expenses, transportation, and modification for vehicles, none of which may be reimbursed by an employer or others. So these would be expenses that would be paid by your student in order for them to be able to perform their task at work. A subsidy. Social Security determines the actual value of that beneficiary work, and if any excess amount is paid by an employer, is a subsidy. So for example, a job coach may provide assistance which shifts some of the beneficiary's work onto the job coach. The value of that work is done by the job coach, no matter who is paying for the job coach, and that is subtracted from the earned income when determining a beneficiary's substantial gainful activity. Continuation of Medicare. So at the end of the trial work period, if a beneficiary who is still disabled loses benefits due to exceeding substantial gainful activity, Medicare Part A, which is the hospital, home, and nursing care, may continue for a minimum of 93 consecutive months, 7 years, and 9 months. Medicare for people with disabilities who work. Individuals with disabilities who have not reached age 65 may buy into Medicare Part A, and once Part A is purchased, Part B and D are also available for purchase. SSI work incentives, earned income exclusion. So with this, basically, is earned income exclusion of $65 from the amount of money gross income that is earned by that beneficiary. There's also a student earned exclusion. So for 2021, that amount is $1,930 per month, with the maximum being $7,700 per year. This is available to persons under age 22 who are regularly attending school. SSI work incentives expenses. Similarly to SSDI, there are work-related work expenses that are paid for by the beneficiary that are related to their employment and their disabling condition. These are deducted from earned income and cannot be reimbursed by employer or others. Blind work expenses are related to employment, but not necessarily blindness. And these broader expenses may be applied to include earned income that pays income taxes and meals while working. So let's do our little pop quiz, shall we? So we have Arnold, who is receiving SSA disability benefits or disability, and he's working at a tri-county sheltered workshop and is receiving approximately an average of $425 a month. Is he still eligible for benefits? Yes, because Arnold is working at a sheltered workshop and he's working under that $940 for the trial work period, as well as the amount for the substantial gainful activity. Arnold would be eligible in order to continue working in a sheltered workshop. We also would be looking at in situations with work-related expenses and other subsidies in regards to Arnold's employer for Arnold to be still eligible for benefits. Let's try pop quiz question number 2. Arnold's working at a local Motel 6, earning the same income. Would he be eligible for benefits? Same thing. Arnold would be working less than SGA, as also less than the trial work period. We'll also look at Arnold having any impairment work-related expenses, such as transportation, if he needs a job coach, and any other needs that he would have in order for him to be able to work. Plans to achieve self-employment, or a PASS plan. SSI recipients or possible recipients can set aside other income in pursuit of a work goal that will reduce or eliminate beneficiaries' Social Security benefits. This could be something as simple as maybe purchasing a car for transportation if an area does not have transportation, or maybe setting aside funds in order to receive a further educational goal that's not covered by vocational rehabilitation, or maybe perhaps starting their own business. Individuals who are receiving Ssdi may become SSI eligible if they set aside the Ssdi funds in a PASS plan. The PASS cadre is in Birmingham, Alabama, can set up a PASS plan. Before you start saving funds, please make sure that you do have a PASS plan approved by Social Security before you begin. Expedited Reinstatement. This is an incentive that comes available after benefits are lost due to reaching substantial gainful activity. Within 5 years of loss of benefits, they can be reinstated if the beneficiary can no longer work without a need of a new application. Temporary benefits may be provided up to 6 months when an eligibility determination is made, and this is applicable both to beneficiaries of both the Ssdi program and SSI programs. Workforce Innovation Opportunity Act, WIOA. So the Workforce Innovation Opportunity Act, or WIOA, was signed into law on July 22, 2014. And basically, it became effective on July 1st, 2015. And it affects the Vocational Rehabilitation Program regulations as well as the Client Assistance programs. So Pre-Employment Transition Services, or pre-ETS. WIOA has increased services to youth. It emphasizes the need for youth with disabilities to have more opportunities to practice and improve workplace skills, to consider career interests, and get real work experiences. It expands education and training options to help participants access good jobs and advance careers. It helps disadvantaged individuals and unemployed youth earn while they learn. And it aligns planning and accountability across core programs. So these types of services include job exploration, work-based learning experiences, which may include in-school or after-school opportunities, or experiences outside the traditional school setting, including internships, and is provided in an integrated environment to the maximum extent possible. It also provides counseling on opportunities for enrollment for comprehensive transition or post-secondary educational programs at an institution of higher education. It also provides workplace readiness training to develop social skills and independent living, and instruction in self-advocacy, which may include peer mentoring. Who are the pre-employment youth? So these are youth, individuals with a disability who are between the ages of 14 and 24 years old. They are eligible for VR services. They are no longer potentially eligible. So this is a larger group than students with disabilities. 15% of each state's public VR funds must now be used for pre-employment transition services. So this is in addition to the transition services which must be retained. So for students, the employment outcome may be a projected post-school outcome. So your student may have a goal in mind of what they want to do once they leave secondary school or high school. And this would basically, with WIOA, be able to start looking at those outcomes and what is needed in order to pursue that outcome as a goal. WIOA with DVR/DBS role in transition. DVR/DBS should participate actively throughout the transition planning process, not just when a student is near graduation. DVR/DBS is expected to provide services to at least some students with disabilities while they're still in school. So if you hear otherwise, basically, please contact Disability Rights Florida for us to assist you. When transition services are being provided by DVR/DBS, as with any vocational rehabilitation services, they must be designed to promote or facilitate the achievement of employment outcome as outlined in the student's IPE. The congressional intent for WIOA was to increase focusing on serving the most vulnerable workers, low-income adults, and youth who have limited skills, to focus on increasing job skills, career pathways, and in-demand occupations, to focus more on employer engagement, and require public Division of Vocational Rehabilitation / Division of Blind Services and the Workforce Development System to become better partners. So under WIOA, we're looking at the inclusion of customized employment to encourage individuals to pursue careers in advanced training in a science, technology, engineering, mathematics, including computer science, medicine, law, or business. So it does not just stop at the lowest level of education possible. It is supposed to be advanced training in order to help that individual meet their employment outcome. They also provide extended services to youth who are receiving purported employment services. So dealing with WIOA and sheltered workshops. So before working at a rate below minimum wage, the youth with disabilities must receive a pre-employment transition services, be referred to VR for services, and receive career counseling. VR must review those individuals employed in a non-integrated setting semi-annually and report information about individuals in extended employment to the Wage and Hour Division at the Department of Labor. Meaning that if you have an individual who is working in a sheltered workshop or supported employment receiving less than minimum wage, VR must review those individuals semi-annually to make sure to see whether or not they are to stay at that level or whatever services or training they would need to move them to a competitive related job in an integrated setting. Florida Medicaid, working with people with disabilities. This is a newer program that has been put in place to help younger individuals be able to work and be able to retain their Medicaid while they're working. So what is working people with disabilities legislation? In 2019, Working with People with Disabilities legislation allows individuals enrolled in certain Medicaid home and community-based waiver programs to have increased income and asset limits while continuing to be enrolled in Medicaid. The legislation increased the Medicaid monthly income limit up to 550% of the federal benefit rate for individuals with earned income through paid employment. Cash assets can be up to the amount of $13,000 for a single individual and $24,000 for a couple. In addition, this program allows participants to have a retirement account recognized by the Internal Revenue Service. So what does that mean for my student? That means that if you have an individual who is working, they're allowed to be able to keep up to $13,000 in cash benefits, assets, for an individual and $24,000 as a couple. They even allowed them to keep it in a retirement account. So you're looking at SEPs, 403Bs, 401Ks, Roths, and etc. as long as they're recognized by the Internal Revenue Service. Who qualifies for this program? So people in Medicaid can qualify if they're enrolled in a developmental disability individual budgeting, or meaning the I-budget waiver, or they're on the long-term care waiver, or they're on the familial dystonia waiver, they're 21 years old or older, and their income and assets come from earned income through paid employment. You have to be having your assets come from earned income through paid employment. How much money can an individual earn? Well, the 2020 limit, which has not been changed at this recording, the individual cannot make more than $4,306 monthly. A couple cannot make more than $8,612 monthly. How much can I save? So there are limits on how much you can save through this program. The individual cannot have assets more than $13,000. Normally under Medicaid, that asset limit would be $2,000. And a couple cannot have assets more than $24,000, and normally their asset limit for them under Medicaid would be $3,000. Can I save for retirement? Yes, you can. Participants are allowed to have a retirement account as long as it's recognized by the Internal Revenue Service. Warning, warning, warning. I have to give you this warning. If you're enrolled in one of those include waivers and receive supplemental security income, you have to report your changes of employment and or increased earnings to the Social Security Administration through the standard reporting process. So below, I have the phone number for Social Security Administration, which is at 800-772-1213, or you can visit the website at www.ssa.gov. If you're enrolled in one of the individual included waivers and you do not receive SSI, you're going to please report your changes in employment and or increased earnings to the Department of Children and Families through the standard reporting process. And you could call the Department of Children and Families at 850-300-4323 or visit www.myflorida.com/accessflorida/. How do I apply for coverage under one of those waivers? Well, again, you're going to basically contact the Department of Children and Families with that link that was online with the www.myflorida.com/accessflorida/. Please sure to indicate whether you're interested in applying for services under the waiver program. There is no special application for coverage while working people with disabilities. You just have to make sure that you're under one of the Medicaid eligible waiver programs. What happens if my increased earnings disqualify me for SSI? Will I lose my Medicaid and waiver services? If you lose your SSI based on increased earnings, DCF will receive this information in a termination file from Social Security. DCF reviews the income and assets of the people listed on the file to determine if their Medicaid can continue. As long as your monthly income is under 550% of the federal benefit amount and the cash assets are under $13,000 for an individual and or $24,000 for a couple, you will be able to retain your Medicaid and waiver services. SSI redetermination. At 18, a review is scheduled to determine whether or not the condition or illness still meets the Social Security Administration definition for disability for an adult. The SSA redetermination standard. Adult standard includes a showing of inability to perform any jobs that exist in substantial numbers in the national or local economy. To be found disabled under the adult standard, young adults must at least be able to show that they are 1. Unable to meet the basic demands of at least sedentary work on a sustained basis, or unable to meet the basic mental standards of simple, unskilled work. When the case is reviewed, the evidence from all vocational, medical, and educational sources should be obtained. The medical evidence can come from medical practitioners, including doctors, nurse practitioners, physician assistants, naturopath, chiropractors, therapists, physical, speech, and occupational, and psychiatric social workers, PSWs. Not having recent records of medical treatment, vocational services, or education services may result in a finding that the illness or condition is no longer disabling for an SSI benefit recipient. Transitioning youth should continue to see their doctors and other medical professionals, participate in the appropriate education or vocational training, especially if there's no recommended treatment for the disabling condition, and provide Social Security Administration with access to all medical, vocational, and educational reports. According to the Social Security Rules 09/2P, documenting a child's impairment-related impairments, this regulation gives extensive discussion of documenting a childhood disability through IEPs. IEPs also can be used to document disability of a young adult who is 18 to 22 years old and who is still in special education. So if you have a young adult who is still attending a secondary school for FAPE, you can also use an IEP as part of the SSI redetermination process. According to SSR 11-P, regarding documenting and evaluating disability in young adults, this regulation considers individuals from 18 to 25 years old to be young adults. Therefore, Social Security will use the same criteria in determining disability for older adults. However, Social Security will take into consideration any documentation and information that is available from non-medical sources such as social workers, therapists, vocational coaches, and family members. Warning: the loss of SSI benefits through a finding that the youth is no longer disabled may result in the loss of Medicaid as well as the loss of Medicaid waiver services, including developmental disabled waiver. This is different from the Working with Disabilities program in regards to where an individual is working, or if somebody's using a ticket to work program with a employment network. Warning also, living arrangement and food provided by family may be considered in-kind income that can affect SSI eligibility. The same applies to income from a parent or a spouse that may be deemed to that youth. Let's go to our last pop quiz question, number 3. So David is a 19-year-old student who still attends high school. He has an intellectual disability of full-scale IQ of 65. What documentation can you use to determine he's still eligible for SSA? Well, there's many documentation you could use. Many things such as David's IEP, documentation from his counselors, his school counselors, his vocational coach, his job coach, his evaluations from vocational rehabilitation, his IPE, information from his doctors, his naturopaths, chiropractors, psychiatric social workers, therapists, other therapists such as physical therapists, occupational therapists, and speech therapists. And all of those could go into helping David in regards to his redetermination of disability. Continued payment. If a finding that a person is no longer is disabled, Section 301 may allow an SSI beneficiary to continue receiving SSI benefits, including ancillary benefits like Medicaid. SSI benefits may be protected when a youth participates in the appropriate vocational rehabilitation program or similar service. The appropriate vocational rehabilitation program or similar services include Ticket to Work, an IPE through a vocational rehabilitation agency, a plan to achieve self-employment or PASS, an IEP for an individual ages between 18 and 21. To be eligible for a Section 301 protection, an individual must already be participating in a vocational rehabilitation program or similar service at the time of disability cessation. Protected Medicaid. So if SSI cash benefits are lost because the childhood disability benefit exceeds the income allowance by SSI, the ancillary benefit of Medicaid eligibility can be preserved. Childhood disability benefit eligibility, formerly known as the Adult Disabled Child or DAC benefit, are 18 years age or older and disabled before age 22. Meaning that the individual is over 18 but has to be found determined disabled before age 22. They have parents who are disabled, retired, or decreased insurance workers, meaning that they too also receiving Social Security benefits. They apply for an application for child benefits and they're unmarried. If the adult child does marry, the benefits will end unless the marriage is to another Social Security beneficiary. Eligibility: over 18, have blindness or disability which begins before age 22, that is entitled to Title II benefits on the parent's records due to disability, retirement, or the death of parent, and loses SSI due to be either the receipt of that benefit or the increase of that benefit. And SSI eligibility will continue in absence of Title II childhood disability benefit or such increases to that benefit. So in other words, if that young adult goes from SSI and that parent is either the disability, the death, or retirement of that parent, then that young adult will move from SSI benefits to Ssdi benefits, which may make them ineligible for SSI because the amount of money may be increased. (1619B) Medicaid while working. This is different again from the persons working with disabilities program. An individual who earns enough income to become ineligible for SSI can still maintain Medicaid health benefits. The receipt of 1619B Medicaid protects the individual for restatement of SSI benefits should countable income decline, and it also protects the eligibility under the state Medicaid waiver programs while working. For 1619B Medicaid, to be eligible, you must have a disability, meet all SSI eligibility requirements except for the accountable earned income, have received SSI for the previous month in an eligibility period, need the Medicaid, and not have earnings that will replace the SSI benefit, the Medicaid benefit, or any personal care services that are paid for by public funds. The Extended Foster Care Program. This started on January 1st, 2014, and the youth has a choice to stay in foster care until age 21. This program will give kids or young adults living options and a support network in order to assist them for the transition to adulthood. Young adults with a diagnosed and documented disability may continue to reside in extended foster care up until their 22nd birthday. At age 18, and to be residing in foster care is one of the eligibilities, and attending high school or working on GED, or enrolled in college or vocational education program, or employed for at least 80 hours a month, or participating in a program designated to promote or eliminate barriers to employment, or have diagnosed and documented disability that will prevent that young adult from participating in any of the activities listed above. Transition checklist. So let's look at our transition checklist of how we're going to get our young adult ready. So we start planning early. A well-managed transition provides a chance for the greatest possible independence, employment opportunity, and fulfillment, preferably starting at age 14. So you apply to the Division of Vocational Rehabilitation or the Division of Blind Services as appropriate, starting at age 14. You invite that representative from the appropriate vocational rehabilitation agency to the IEP meetings. You ensure the coordination of the IEP and the IPE through both the school and the vocational rehabilitation agency. You apply for available services and scholarships, i.e. waiver programs, VR services, RTI, etc. And you keep a watchful eye and seek assistance with income and benefits issues. You're going to contact the WIPA programs or Disability Rights Florida with questions about the interplay of work, income, and benefits. Seek assistance in case of overpayment for Social Security benefits. Continue to see doctors to understand disabling medical conditions. Determine if that individual youth can handle their own Social Security and health benefits, and who will assist them if they need help. Identify accommodations that the youth will need in employment or in a post-secondary educational program. Remember that earning wages causes the SSI benefit to decrease, but increases overall income. Work puts a person with a disability on the path of being an insured worker. How can we assist at Disability Rights Florida? Well, we advocate for the rights and needs for people with disabilities with both of the state vocational rehabilitation agencies. We have what they call the Client Assisted Program, which is housed here at Disability Rights Florida. And we would help with situations with the Division of Blind Services as well as the Division of Vocational Rehabilitation. And we also address other employment-related issues such as employment discrimination, reasonable accommodation, work-related transportation, centers for independent living, Social Security work incentives and WIPAs, employment networks, and other barriers to employment. Thank you for listening. My name is Z. Felicia Jordan, and I'm the Director of the Social Security Representative Payee Program here at Disability Rights Florida. The phone number is, you can reach us and reach for assistance is at 850-488-9071 or 800-342-0823. Or you can reach us at our website at www.disabilityrightsflorida.org. The resources we have is listed below that gives you some helpful links that you can find to be able to help you on your path of transition. Further, your input matters to us. So please participate in our 2022 Public Input Planning Survey. Please visit the link below now through July 31st, 2021 to complete our annual Public Inputs Planning Survey. Your responses will help us plan our goals, priorities, and objectives for the year of 2022. The link below is at www.disabilityrightsflorida.org/survey. And thank you for listening.